jurisdictional court. Hence, the petition is dismissed. Learned counsel appearing for the petitioner submits that when in the cause title, the petitioner herein, who is a respondent in the petition, is shown the respondent herein. It is admitted that they have filed voluminous documents to show that there is no relationship between the petitioner and the respondent, and the marriage is not consummated. In those circumstances, when there is no relationship of man and husband and wife, question of restitution of conjugal rights will not arise. And as such, they have come up with an application under Order 7 Rule 11 to reject the petition. Next para. This court has heard the counsel for the petitioner and perused the order impugned. When before proceeding with the matter, it is appropriate to extract or look at Order 7 Rule 11. Please extract Order 7 Rule 11 in the order. An application for rejection of the plaint can be filed on any of the grounds enumerated under Order 7 Rule A to D. When it is settled law that while rejecting the plaint, the court can only look at the plaint averments but cannot look into any other documents. Court cannot even look into the written statement, objections. Looking at the plaint, the respondent herein has stated what is the cause of action, when the cause of action arose, when they have married, and on what reasons he is seeking restitution of conjugal rights. Now the petition, whether the marriage has taken place or not, and all the contentions that are raised by the petitioner herein can only be considered by the court after a full-fledged trial, but not in an application under Order 7 Rule 11. All the objections, contentions that are raised are beyond the scope of an application under Order 7 Rule 11. The court had rightly considered all this and rightly dismissed the petition, and this court finds no reasons to interfere. Next writ petition, WP 21780 of 2025. Agreed with the order dated 15/4/2024 in MC number 2279 of 2024, the petitioner is before this court. The first part, the introduction of facts in the other case, same year also. Now, an IA, it is the case that as the petitioner is not married to the respondent and her marriage is fixed, and as the petitioner, as the respondent herein is interfering, an IA was filed seeking injunction. In that IA, for objections, the matter is adjourned. However, the court had passed an order that till the disposal of the IA, the petitioner herein is directed not to enter into marriage as referred in IA number 2. This order is dated 15/4/2024. Land Council submits that the court ought not to have passed such an order. And also, it is a fact that pursuant to the order passed by the court, the petitioner herein is already married, and the respondents have already preferred. The respondent have already filed a contempt as the petitioner has married. This order is passed on 15/4/2024 and the writ petition is filed on 10/7/2025. Just because there is no limitation for filing this, the party cannot be permitted to assign an order after 1.5 years. On all these counts, this court is not inclined to interfere. Dismissed.
Petitioner millets. Because here the petitioner and the respondent are husband and wife millets. Marriage has been solemnized in the year 1990 millets.
What are you seeking?
Enhancement of interim maintenance.
What is? Same hands amounts?
Please.
husband's petition, my lord, challenging the IA number 6, seeking the rejecting of application filed by the husband, seeking the appropriate action against the wife respondent to violation of the for violation of the order on IA number 5, my lord, which is granted under custody of the child,
Page number,
to have the custody of the child, my lord.
page number.
Impugned order is at page number 12, my lord. Operating portion is at page number 22, 18 onwards, my lord. On page number 20 onwards, my lord. But the wife has filed the petition seeking divorce, my lord, against the husband, in which the husband has filed the statement, written statement saying that he is ready to take her back along with the child. Though the several mediations were made, my lord, she has not agreed to join the husband. The husband has made her to get the
Notice.
council notice may be ordered, my lord. Acha.
And summons.
Respondent in this case.
I'm appearing for the petitioner, Your Lordship. On the last occasion, Your Lordship had asked us to direct presentation of the councillor's report. Now, on page number 99, Your Lordship, we had already furnished another councillor's report. This is from the New Life Counseling, Healing and Research Center in Mysore. The child, I believe, has been continuing to go there until 2023 November.
It's an old report.
It is an old report. Unfortunately,
Wanted that day is, what has happened
Yes.
from there on?
yes, I was coming to that, Your Lordship. She has not been able to go back to them and obtain the reports.
It's not about going back. If you are going every day, you will
Yeah.
get a receipt for that. You will have at least some scrap of paper.
Until 2023, mid 2023, the child was going to that center on and off. And subsequently, she has
I
been,
can understand. Now, the child is not interested to meet the father, and neither the mother makes any efforts to see that the child meets the father, no. Or makes some effort to see that the child gets some medical
Yes.
help. That is also not done.
Your Lordship, there is a doctor, there is sort of a psychologist that the child is consulting with. Unfortunately, that psychologist is not available for the last 3 weeks. She is on a personal travel, which is why we had requested for a time in the next week for us to obtain those reports. Having said that, Your Lordship, we have also filed an application in the trial court requesting the trial court to send the child for an independent evaluation at NIMHANS or any other recognized body.
No, you take him to the man's. I'll
Most
pass on
obliged.
order.
That application
take
may
him-
be disposed because
It is submitted that
Yes.
on the last occasion, when the matter came up, it is submitted that the child is interested not to meet is not interested in meeting the father. Then this court has asked the mother to place before the court, what are the steps taken by the mother to see that the child develops bonding with the father, or the with the father, or any help is provided with the counseling in that regard. The wife wanted the counsel for the petitioner mother wanted to get instructions. Today it is submitted that she was continuously taking. The concerned counselor is not available, and in fact they have filed an application before the family court to send the boy,
daughter, Your Honor.
Huh?
Daughter.
send the daughter for a independent for an independent analysis of the girl, why the girl is not interested to meet the father. Considering the same, the mother shall take the child to the NIMHANS, and the doctors at NIMHANS should evaluate and place the report before the court. On that day, the girl shall be taken to the NIMHANS on 6th of September, It's a Saturday.
Can we keep a flexible few dates, Your Honor? Like
My
to
lord,
us
my
to get
submission,
back.
my,
That's how it won't
My
possible
lord,
because
my
they
lord.
are busy. Nimhan's people are busy.
Maybe
My-
any of those days, 6th
Huh?
or any of the, at least two
my
options, Your
lord,
Honor.
my lord, my submission is that, my lord, since from 2022, my lord,
6th of,
continue, there is a
6th
continued
of
direction from the
September.
family court.
It shall be taken. And while the Nimhans, the doctors at Nimhan shall interact with the child along with the mother and also along with the father and submit a report before this court. This matter on 11th of September.
Your Lordship, on last occasion, last occasion, my learned friend had made a submission that one of the reports that we submitted was issued by an eye specialist.
Yes,
I
definitely.
have got it confirmed that he's not an eye specialist.
We will look into that.
He's a
No,
general
it is there,
practitioner.
my lord.
It
It
is
is
not
there,
a-
it is there. Your lords may
Not.
kindly look into that.
Even his
It is my
letterhead
lord's
does
my-
not
Now,
confirm.
what I see is we have to look at the issue on a solution
Yes, yes.
oriented view. Now, girl is going to the Nimhans,
Yes.
father is going to meet her there. So I think you better, both of
My
you
lord,
have to
one,
reserve the
let
energies.
there be a direction to the mother, my lord. Inform the father to accompany the father, the date.
No, you go to the
You're
Nimhans.
already aware
No,
of it.
because unless and until.
You shall inform the council what time and,
When they shall go to the Nimhans at 10:30 on Saturday. You go to the Nimhans at 10:30, the father shall be informed about the timings and at 10:30 you have to go
No,
there.
no, but place where and Nimans means is a huge hospital and all.
How will she
They have to
know?
let them give
They
the
have,
message.
they will also go there.
Yes, ma'am.
As this is how happened, that's what she can't tell you where and when. Unless and until she goes there, she can't know.
No, my lords, otherwise nothing will take place,
I
my
think for
lord.
the first time
Because
somebody
they should
has-
also, wife should
No,
also
this court-
cooperate,
this
my
court
lord.
has passed so many orders till now.
Yes.
Nobody has raised this doubt till, like, nobody has asked the court to even inform where, how,
And your
when.
lords may, last case, lordship was directed them
Yes,
to
next.
produce all the reports and all.
Yes, please.
My lords, let them at least, let there be direction to cooperate with the husband, my lord. Otherwise, they will not,
we shall inform
they
the
keep on,
council.
this is what your lords may kindly appreciate. Whereas in 498 case, my lord,
Next.
9 days of hearing, she is not at all present. She was absent.
Yes, please.
I appear with the petitioner. Because in this matter, the respondents were directed to file their affidavit of expenses. Time and again, they've sought adjournment on one pretext or the other.
Well, Lord's, the affidavit has been filed. We filed the affidavit.
I'm ready.
Have you received the affidavit or not?
They filed an affidavit stating that it is not an exact mention of what is that they're incurring
have-
expenses.
Then what I understood is that they have not filed the affidavit.
They have a problem with the contents of the affidavit, but the affidavit
I-
itself has been filed.
Please, if this is what they want to rely on, I have no issues, ma'am.
That the court will see.
Please.
Yes.
Now, the question would come up to is how much that, based on their expenses that she's incurring, how much would be granted to her? As of now, as I
What is
pointed
the
out
impugn
earlier.
order? Come to
My
the impugn order first.
Page number 60. Page number
That's page
64, my
number
lord.
51 to 66.
66.
Page number 62 is the operative portion.
Court has granted 1 lakh.
1 lakh. My lords, your lordship's order on 10/9/2024, based on which there is an order on 10/9/2024. The
If it
affidavit,
takes some time, we'll see tomorrow.
please, my lord.
Please, my lord.
Yes, next.
My lords, interim order may kindly be.
Tomorrow order granted is extended. 29.
Please.
In this matter, in the earlier occasion, my lords, this honorable court has directed both the parties to file a memo of calculation, my lords. They have filed the memo of calculation. I have to file a rejoinder for that, my lords. I may be placed for a 2 days accommodation, my lords.
This is matter on 26th of September. Yes, next.
Ma'am, my lords, 26 is a holiday, my lords.
of September.
Oblige, my lords.
There
Yes,
is no
6:30.
payment as complied, my lordship. Month of June onwards, we are not
Finally, my
receiving
lords.
that. Monthly 60,000 they have to deposit. Till the January they paid, and after the February to May, continuously they paid. One time they paid. There is no monthly payment.
Interim order
Kindly, my
complied
lords,
with or
before
not?
the trial,
Interim
kindly, my
order
lords.
complied with or not?
comply, it is complied, my
The
lords.
interim order is not complied with or the
My lords,
stay
one
granted-
submission, my lords.
The stay granted by this court stands vacated.
My
Without
lords,
further
one
reference to the
submission, my
court.
lords.
In the
My
June,
lords,
No submission is required for that.
my lords, one submission, my lords. They are falsely stating this before this honorable
I am
court,
not,
my
I
lords.
have not said anything. I said if the interim order is not complied with, the stay granted by this court stands vacated. If you are complying with, why do you worry?
Oblige.
Yes, next.
Execution order, my lords, is under challenge. So initially, my lords,
Any urgency in this?
I have not.
Yes. This is matter on 16th of October.
It's
Interim
interim
order
order.
earlier granted is extended.
Date.
Yes, 31.
Father's petition, please, my lords.
To place on records with regard to whether the child has got a holiday on Saturdays. Filing the affidavit, my lord, and also the document secured from the school. Saturday. is
Tomorrow
not-
we'll see this.
My lord,
Tomorrow. Yes, this is matter tomorrow.
Let's, may I request it, let it be in the first list, please, my lords.
That I cannot say. It can't be because by already first list is ready by this time. Yes, 32.
next week, my lord,
No, no, tomorrow.
tomorrow.
Yes.
Appearing for responding to this matter.
Interim order is there.
No interim order.
List is matter on 19th of November. No representation for the petitioner. Yes, 33.
Respondent,
For the petitioner, my lord.
they have not complied with the interim order, conditional order.
Not complied.
I have complied, my lord. I have deposited first half of the amount before this honorable court and remaining directly to the account.
They are required to pay 1,80,000, 50% of is 90,000. They have paid 55,000.
No, my lord. 5,000 rupees per.
Counsel for the petitioner as well as the counsel for the respondent shall file the memo of calculation.
Please, my lord.
List the matter on 28th,
Please, my lord.
28th of August. Yes.
This case, my lords, custody has been ordered in a section 9 petition, my lords, restitution of conjugal rights. When the matter is posted before this honorable court, my lords, it's referred to mediation. Thereafter, mediation is failed. The order is that, my lords, every Saturday, respondent has to visit the house of the petitioner, and alternatively, every Sunday, petitioner has to go to the respondent's house, my lords, along with the children, my lords, every Saturday. Both are working. For the first 5 days, they are working, my lords. For the Saturday, Sunday,
See the impugned order, please come
Please.
to the order.
at ink page 80, my lords. When the matter is referred for the mediation, originally, my lord,
Petitioner is referred is to the father.
petitioner is mother, my lords.
Mother filed the MC.
Before restitution, father, my lords.
This
Before-
order is passed in the MC.
Yes, my lords.
MC for restitution
Restitution, my lords.
filed by the wife.
No, father, respondent father, husband.
In that mother files for visitation.
No, father himself files a visitation right, my lords. And he files a separate petition for custody of the children. That has been withdrawn after passing this order, my lords.
What is the age of the children?
6 years and 4 years.
From when they are living separately?
So 21, my lords. 26/7/2021, my lords.
20?
27/7/2021.
No, please read the order. You said so many things. I do not find all that.
Yes, my lords. So that's what I am saying, my lords. Originally,
Read this order.
yes. Before that, my lords, I'll see the facts, my lords. Otherwise, it will lead to confusion, my lords. Originally, petition was filed in Mangalore, my lords. Thereafter, by way of order of this honorable court, this has been transferred to Bangalore court, my lords. In Bangalore, my lords, he filed the application for custody of the child in section 9 restitution of conjugal rights petition, my lords. that application, when the application is filed, there also court referred for the mediation. In the meantime, court suggested both the parties to make arrangement Saturday and Sundays, my lords. In a goodwill, my lords, both the parties are agreed and mediation is filed. And that order is continued by the trial court, my lords. Thereafter, I filed application for modification of that order because the son is going to the school and now the small kid is also going to the school. Every Saturday, Sunday is a difficult situation and they can't go anywhere because of this order. And I filed modification to the effect that once in a month, visitation right may be allowed. And he filed application for modification of the order stating that 50% of the custody of the children will have to be given to the respondent herein. And that application partly allowed by way of impugned order and my application came to be rejected. And partly allowed the impugned order stating that, my lords, 8 days custody in summer holidays, 50% custody in Dasara and Christmas holidays. And these small kids, they will not go without the mother, my lord. And because of that reason, she is in a trouble, my lords. Whenever she goes, he is abusing her. You are ashamed to sit in my car. You are ashamed. So many allegations will be there by him. Even twice she is agreed to return to the husband's house along with the kids. He is insisting to get the property of her father. And he says that, well, I am not asking for that property. It is my child's right, the children's right. It has to come to me and it has to be decided. Without that, I will not take the wife back. And he is not paying a single pi as maintenance to the kids. He is seeking custody. Even now, I am not objecting for that, my lord's visitation. But every Saturday, Sunday, it will spoil the kids' career. I can't take them.
Where do you see that? That I am not able to find.
Please.
Saturday and Sunday, where are you getting from the
Please,
impugned order?
para 2, my lords. Sorry, para 3.
I am looking at page number 80.
78, my lords.
Operative portion.
Allah, that is with regard to IA number 5 and 6 with regard to modification of the order.
Where is the original order?
I have a copy here.
The respondent has para 3 there.
No, you are supposed to question that. You can't. You have to question that
No,
order.
no. I filed application for modification.
That is why he's.
Modification order.
That order has to be here at
Yes,
least.
IA number 6.
Page number.
81, my lords. IA number 6 filed by the respondent and so and so seeking
I'm
modification of
asking,
the order
where is
dated.
this order dated 18/12/2023? Where have you filed this? 18/12/2023 order.
Copy. No. That order not modified, my lords.
I understand that. It is dismissed. What is the modification you are seeking? To know that, I have to look at that order.
Please, my lords. I filed application, my lords.
Where is that?
Ink page 58, annexure F. For the reasons stated in the accompanying affidavit, it is humbly prayed before this honorable to modify its order date on IA number 2 dated 18/12/23 and direct the petitioner to exercise visitation rights only on one
If I am
Sunday.
asking for this order, I am looking at it.
18/12 order. 18/12 order.
At what time is the meeting? At what time is the meeting? What is the distance between both the houses?
Less than 1 kilometer.
Around 1.5 kilometers.
Well, when the husband wants restitution, in the restitution he is seeking all these orders. Why is he not joining when the wife is ready?
In fact, each time reconciliation was suggested by the respondent husband. Even before the High Court, when we had come before this Honorable High Court, it was me who had suggested let them go for mediation, even for the second time. However, in fact, every Saturday, Sunday, the children are now finally meeting the father. Petitioner wife is also going on day one to her house. He goes to meet the wife and the two children. Two children, petitioner is there. Sunday, she comes 10 to 5. With
No,
the
no,
two
no, I
children.
am,
Yes.
you
So
please
what
answer
I-
to that.
Yes, yes. So there appears also to be a certain type of what is it, the mutual compatibility or agreement or something between them. Because they are also meeting. So which is why we said well, this is a perfect matter for the parties to reconcile. However, he is, in fact, his parents were here, families, they are very, very, even today he is saying even whatever the situation is, even for overnight custody, if she wants to come, he is completely open, one, to reconciliation, and two, to consider any kind, maybe in the interim, if they need some time, maybe they can increase the amount of time because he's living
What
just-
he is submitting is,
Yes.
your client is not ready to take back.
Each time we are the ones who are, in fact, on the 27th.
So on
of
what,
July,
why the mediation is not working out?
my lords, they are.
May I make one
He
submission?
yes, yes. He has been, I think there is just some, if I would say, this is something where maybe they have some issues regarding either saying things to each other or, and just working out daily living. So this is something which maybe on a deeper level, which is what I had suggested even in one of the mediations earlier. If a counselor or something could step in to see whether this is a possibility. Otherwise, actually, and if my lord will have a look at the writ petition or any
Where the
case filed
parties,
by them
where the parties are residing?
in
In Bangalore,
Vidyaranyapura. Yes.
Vidyaranyapura.
Yes.
This is smarter.
One thing is that, my lord, she agreed for everything, my lord. She
On
And I had
asked us to,
30th is a working Saturday. This is matter on 29th, Friday, in chambers at 5 o'clock. Both the parties, along with the children, shall be present.
please.
Yes,
Well, look, in the meantime, he is not getting access. In fact, learned
next week,
I'm sorry.
next week.
Yes, yes. All right. I'm good.
Yes.
Hello. As per the detail, so.
Where is the interim impugn order?
Page number operating 25 million.
20?
5.
How much is granted?
It is 6,000 to the first petitioner and 12,000.
First petition is wide.
Please.
And
12,000 to the daughter.
who is petition number 2?
Daughter.
How old is she?
17 years.
17 years. What is the salary of the husband?
Salary of husband, your lordship, admittedly, your lordship, see overall, 53.
Gross salary is 65,000,
55.
640, 46,432.
Please. Fourth, out of that, the aged parents are there, and not only that, actually, he has made a house and he is interesting to live together. He has taken the house for that. He is very much interesting, and not only that, he is paying the school fees of the daughter, and your lordship, the overall 3,31,495 he has paid. But as for the even interim order, 3,24,000 is comes as per the calculation.
My lord,
And
they
that-
only paid
And even recently today in the Tumkur court, actually they have got some settled. That's what I got an information by the husband today. And the husband is very much interesting to live together, and he's taking the aged parents, and out of 34 he's making payment 70,000, 50,000, 20,000, 40,000 like that. 3,31,495.
No, they only paid.
As on the date of filing this petition, he has paid.
Till date, my lord. They still have 1,45,000 till date.
Accumulating is the
They have to
3,24,000.
pay 2,33,000.
Yes.
And more than the arrears he has the paid, and he's still also he's paying. But in addition to that, what the trial court has meant that in spite of this interim order of this honorable court, they have attached their salary, and even the salary is also they have holding. He's not getting the salary from last 8 months. Though there is an interim, in spite of that, he is making the payment also, there is a actually attachment of the salary is passed by the court, trial court. And he interested to live very much with the wife, but she is not cooperating. And he is taking care of the fees, college fees and everything I have paid.
No,
We have
because
this
court has said
receipts.
you pay this amount, pay only this amount, don't pay other amounts.
Pardon?
When the court has given a direction to pay only this amount, you pay only this. Don't pay other amounts.
Because we are making, because last occasion your lordship was suggested to file the memo of calculation. For that.
No,
which-
that will not go into, because
Please.
that's the executing court will take care. We'll only decide whether the order impugned is correct or not.
Yes,
Your
please.
salary after 65 is your gross, after deduction 46,432. So court has granted 18,000 for two people.
And your lordship, the wife, she is the admittedly in her, she is the private teacher and getting the salary.
Where is that admittedly?
That is, your lordship, in para number, page number 23, inside the 13, para number 13.
That is your argument.
The argument, even the petitioner in the declaration of income has, she is a.
And earning 12,000 per month.
12,000 per month. Declaration of the first petitioner is denied by the respondent and containing that petition number 1 is getting the salary of 23,000 and coaching classes of 150 students. She is earning 9,20,000 per year. She herself has declared.
There's no document to verify that.
And admittedly 12,000 she is getting.
What do you say? She's earning.
She's only earning 12,000.
And-
But the tuitions and the college fees
Students-
will come up to 1,30,000 every year, my lord. The child is studying engineering, my lord.
We paid the fees for college admission fees and we have paid.
No,
the-
if we may, then shall I pass an order that entire school fees father will pay, college fees?
Yeah,
There are no maintenance to the wife.
Please,
Entire college
please.
fees you pay.
Please.
My lord, kindly give a small date, my lord. I don't have.
Hello,
any
because she's
instructions
earning
from-
and-
We'll have it day after tomorrow. Get instructions from your client, no maintenance to her.
Yes.
So even that amount, if you take, 6,000 is granted by the court.
Yes, my lord.
It would be around 72,000 or so per year. You're saying that 1.5 lakh is the college fees.
Yes, ma'am.
Let him pay the fees. Let us, whatever is the maintenance that's granted to the
Whatever
daughter.
it is, we'll pay that.
That is granted to the wife. We will modify that order day after tomorrow at the request of Land Counsel respondent. Yes, next,
Your lordship, kindly be Monday, my lord.
Monday.
Please.
Yes.
Entry model. Entry model, kindly.
Not Monday. List the matter on 29th. Interim order earlier granted is extended till then. 36.
Please.
For petitioners, maintenance application is challenge.
Interim order is there
No more, first time is coming. For notice has been issued.
tomorrow. Yes. Yes, 37. This also tomorrow. List after service of notice.
I filed on IM, my lordship, for substitute service.
Paper publication. IN number 3 of 15, the 3 of 25 is filed. For taking out the notice by way of substituted service on respondent number, sole respondent, on the respondent in so and so. 4th September 2025 and mentioning the date of hearing so and so. Yes, next.
Case.
IN number 1 of 24 is filed to condone the delay of 11 days. Condone. Admit post, call for the trial court. Huh?
Interim order, kindly be considered.
Is not there.
Hey, it is not there, first time.
No, will not grant. Interim, the call for the records. Yes, next 3. Notice to the respondents.
Appellant.
What is the reason for this delay? 431 days.
My lord, what has happened in this matter is that
Case initiated against the advocate concerned.
Huh?
Court advocate.
the appellant is 10 standard fail.
Huh?
The appellant is a 10 standard fail.
Hmm.
Now both the appellant and the respondent number one are Mohammedan by faith and religion. That's his first wife. Now,
Let's see the IA.
oh,
IA that is filed.
that page number 54. 54.
What is this?
IA for condemnation.
That's not 54. 56.
55.
Now, his advocate has not contested the matter, has not appeared. When did he know about this case, about this order?
Once he got the summons in the execution matter.
When did he receive the summons?
Yes, madam. Or 2024, my lord, because they have filed criminal miscellaneous 536 of 2024, my lord.
You have filed this on 18 to 2025.
Yes, ma'am.
You have received the summons in criminal miscellaneous.
Yes, ma'am.
You don't even say when you have received. Is it not a relevant factor?
Yes, ma'am. In 2024, my lord.
That's not
At the end of
fair.
2024.
With this inordinate delay, each and every day's delay has to be explained. Not explained.
No, my lord.
Not condone the delay.
No, my lord. Why this matter, my lord? Is because he's married already with a second wife and 3 children. Now the
Merits of the matter.
yes, my lord. The wife had deserted the husband in the year 2008. For around from 2008.
I said it is on the merits of the matter. We have not gone to that level. We are still at the threshold. Unless you pass through, we'll not hear the merits of the matter. Just like that, casually, whenever a litigant feels he can't come to the court, it won't be entertained. Tomorrow.
Yes, ma'am. I'll file a.
I'm going to dismiss this IA.
I'll
tomorrow.
file an affidavit, ma'am, with regard to this
Tomorrow.
matter. Yes.
Yes, 5.
Lord, the ex parte order has been passed with an observation that, and the notice has been unclaimed. The Lordship has called the LCR the last day. Lord, the
We'll have it
entire
tomorrow.
announcement is on the
Tomorrow.
suppressing the income
Tomorrow
tax
we'll look
returns.
into it tomorrow. 6 also tomorrow. Yes.
Lord, in serial number 6, a week
Tomorrow.
time, my lord, I have not received a petition copy.
Send counsel for the petition.
was not ordered.
Huh?
I voluntarily filed a wakalat for respondent.
And counsel for the respondent, counsel the petition, so the copy of the
First week
petition
of
of the counsel
September,
for the
ma'am.
respondent. It's coming up for the first time.
Second time, madam.
List is smarter on 2nd of September. Yes,
Much
7.
Please.
It's for 1 week time, you want to engage another.
List the matter on 15th of October at the request of front counsel for the respondent. In 7, Mr. Harish Kumar MC is directed to take notice.
I am Harish Kumar.
That's why you have to take notice on in 7. Yes, next.
It may be second.
Huh?
September.
2nd of?
September.
My lord,
Because
the impugned,
there are already matters, that's a whole difficulty for the court.
my lord, the impugned order, it's,
11th of September. Yes, 9, 8.
For the petition in this case, my lord. Husband's petition for reduction of maintenance.
This is a matter on 29th August.
My lord. Okay, much.
Number 9, your lord. Serial number 9.
Morning, somebody has asked for adjournment.
Respondent.
10.
And for the applicant, petition seeking for and challenging the order, challenging the 125 order, my lord.
You that. How much is granted?
4,000 rupees.
That also you are questioning.
No, it is dispute between the mother and me, my lord.
Huh?
It is mother and my wife. Respondent is petitioner is the mother, my lord.
Petitioner is the.
No, I am for the petitioner. In the trial code, petitioner is the mother, my lord.
You are seeking enhancement.
No. I am challenging that 4,000.
Devaraja is the son.
Yes, son. It is 125.
What is your income?
I have deposited 10 lakhs in the name of my mother, my lord. And also I have given 18 quotas of land to my mother in the partition, my lord. In spite of that also, she is asking for this 125 maintenance.
Notice, we will see mother 4,000. Notice, emergent notice to the respondent. Yes, 11.
Query for petition, my lord. Office objections have been complied, and I request your lordship may kindly call for records, my lord.
Yes, call for the records. Yes, next. Registry is directed to call for the records. Yes. 12.
And for the respondent, my lord. My lord,
Let's just mark this also on 29th August.
yes, may be disposed of on that day, my lord.
Huh?
Finally, it may be granted.
Yes, next. Tomorrow, tell her that MFA list should be the last list. So the last 2 days it is coming first. MFA should be the third, RFC second, WP first.